Hello, hello, hello. Thank you for joining us again for another Great Money Monday. As you know, my name is Rosalind Brown. I am your host tonight. And every single Monday, we come to you with some actionable insights for you to use on your financial independence journey. And so many people are thinking about, goodness, how do I accumulate wealth? But then there comes this day where you start to figure out, how do I protect the wealth? Maybe how do I provide generational wealth? And so that's where there's another tool that's out there readily available, which is a trust. So many different kinds, so many different ways to utilize this tool. And so we have an expert here today to share some of the ways that you can use this fabulous tool to prepare the next generation, to protect your assets, and so forth. So today we have Nicola Rochester Robinson. She is the co-founder of the SR Law Group, an elder law and estate planning law firm in Douglasville, Georgia. After receiving her undergraduate degree from Emory University, Nicola set her sights on becoming a trial attorney. During law school at Penn State Dickinson School of Law, she quickly developed her trial and advocacy skills working in the Cumberland County Public Defender's office. Prior to starting the SR Law Group, Nicola began her legal career as a trial attorney at the Cozen O'Connor, a nationally ranked top 100 law firm. At Cozen, Nicola worked most notably on litigation surrounding the events of September 11, 2011. In 2009, Nicola began helping friends with estate planning. A few years later, several members of her own family passed away. She saw firsthand the importance of having properly drafted wills, trusts, and other end-of-life decision-making documents. It was through this work that she found her true passion for helping families understand the importance of estate planning and elder law. The sickness or death of a loved one can be emotionally difficult, but it does not have to end in a legal tug of war. She is an Atlanta native and a proud Douglas High graduate. So without further ado, want to hand the mic over to our host for the evening.
Well, thank you so much, Rosalind, for having me. I am so excited to be here. I every time I hear that bio, I'm always so tickled because I think it doesn't do justice to why I really do this work. So I always like to start off by telling people about when my grandmother passed away, because I think that people can relate a little bit more to that. When I was after law school and was already working in big firm and doing all this stuff, my grandmother, who owned a chicken farm, passed away. She had 5 kids, and my father, being her oldest child, was not her biological child. My grandmother did no estate planning, and we quickly saw the turmoil that comes with no estate planning, and it caused a complete tear down the very fabric of our family. My dad and his siblings, they completely fell out. There was a lot of drama, and it has really changed the relationships in our family. So you see, 3 generations have been changed as a result of her not doing her estate planning. And so that's really what has driven me into this area of law. I've seen just firsthand how much wealth we lose as a result of not doing any type of planning. And so my hope tonight is to kind of introduce everybody to trust. Everybody's not familiar with trust. Everybody's familiar with wills. I get people to come in my office all the time and say, oh, I need a will. And so after talking a little bit more, we always realize, well, that may not be the best tool for you. A will is just a tool. Trust is just a tool to be used to transfer wealth. So I'm going to talk about the difference between the two. I ask people to please stop me with questions, jump in at any point. I want this to be as interactive as possible. So let me get slides going. Here we go. So Rosalind's already talked a little bit about me. So, and really what estate planning is just making sure you have a clear plan about who's going to receive what at the time of your death. But I also want people to understand that estate planning also encompasses those documents that will help people to understand what to do with those assets for you in the event that you had a stroke or a heart attack. So people are very quick to think of the end of life documents and the passing of your assets, but we want to also make sure that we think about the documents for if we were sick or if we were ill and somebody else needing to manage those assets. So that all is encompassed in estate planning. And why do you want to do it? A lot of times people have heard of the fights in court. Probate court is another area that I spend a lot of my time in, and it's the discord between family members trying to figure out what to do once somebody has passed away. So you want to definitely do estate planning. If you are not interested in your family spending years in court trying to figure out who gets what, especially if you have minor kids, you have things that you want to make sure gets passed to those minor kids and it's not tied up in court, then you definitely need to see about doing some estate planning. And who does it? So this is what I get people to understand. If you're going to take on the responsibility of making sure you transition your things to your family, then you do estate planning on the front end. If you don't care, and I hear people say sometimes, why do I care? I'm going to be dead. That is a choice. You've made a conscious decision that you're going to leave your family to kind of figure this out and to muddle through and hope that they get it right. So it is a matter of saying, who's going to do the work? Am I going to take on the responsibility of making sure I know exactly what happens to my assets when I pass away, or I'm just going to kind of leave it to chance and hope for the best for my family? And estate planning really comes down to three things. You accumulate your assets, and I'm sure Rosalind talks about this pretty much on this platform about accumulating, savings, investing, growing assets. A lot of times you're going to purchase insurance, you're going to do all those things to make sure you protect those assets. And so this is just the next part of it. It's just making sure we understand that distribution during life and even after the time you've passed away. If you work so hard to accumulate it, we got to make sure we have the right tools in place to put it to good use for somebody else. A lot of times people don't know, okay, what's the asset? What's the estate? Like these terms sometimes don't not readily translate. And so for estates, it does not matter how big or how small. Some people might be in the beginning of their accumulation journey in terms of getting a house or getting a car, real estate, checking accounts, and things like that. But all of that encompasses your estate. And so that's what we want to make sure we plan for with everyone. And I tell people, really, like at the end of the day, I have no crystal ball. So when you come into my office and you tell me the things that are important for you, I help you figure out what's the best way to minimize risk. How can we use estate planning, use wills and trusts to do some primitive action so that if these things do happen, we actually know, okay, one spouse dies first. Well, we can't prevent the second spouse from remarrying, but we can make sure those assets don't go to the next wife. We don't know our kids, futures, but if they do have to file for bankruptcy in the future, we can make sure that whatever funds you leave them are not tied up in their bankruptcy. So it's all about minimizing the risk that we can kind of say, we don't know if it's going to happen, but let's make sure we have some things in place that will prevent them from losing all the money and all the assets that you're wanting to leave them. So these are some of the risks that I talk about with people a lot. People are concerned about whether their adult children can actually manage the funds. Using a trust, that's a tool that will help you to be able to say, okay, I would rather disperse these funds to my children in small amounts because I don't know that they'll be ready for a lump sum. Or you could say, you know what, I'm okay if I pass first and my spouse remarries, that is what it is. But I want to make sure what I've accumulated goes to my children, the children that I've had with that spouse. You want to make sure that as you get older and you're not able to make decisions for yourself, you've already done this kind of planning. So dementia or any other type of, I get a lot of clients who have mental illness in their family. You know that in the event those types of medical things do happen, you've put a plan in place. So you know exactly who will manage the money, who will take care of you, and where the funds will go after you've passed away. And so this is just kind of giving you wills and trusts 101. Please, like I said, ask questions, stop us, interrupt at any point. I'm going to just go kind of quickly about a will so we can get to talking about trust. So, a will, you've heard of them probably ad nauseum. Your last will and testament, and it's really just a legally binding document that says who will take care of following your final wishes at the time that you have passed away, who will carry out the desires that you have documented in this document. To be create a will in Georgia, very, very low threshold. Be over the age of 18 in writing and just have sufficient knowledge of the things that you are actually going to leave to somebody else. I jokingly talk about this all the time because your mental ability to get married is higher than your ability to have a will in the state of Georgia. Georgia just wants you to be over 14. As long as you can do that, they're good with it. So, and a lot of times this is what people know in terms of the benefits of a will. You name a guardian for your children, leave burial instructions, and then you name who's going to receive your property. The downside, and I'll talk about it a little bit in the other slide.
When you talk about being over the age of 14, so does that mean people should be putting together wills for their minor children? So they're 14, 15, 16-year-olds?
So although the requirement legally is to be over 14, I usually say by 18. Everybody at 18 needs to start thinking about estate planning. 14 is not, 14 to 18, usually they don't own a whole lot. So you're talking about leaving your bicycle to your cousin or something like that. They haven't accumulated enough that it may warrant the expense of doing an estate plan. Now, by 18 or the time they start to go off to college is when you really want to start thinking, okay, they're an adult. They've accumulated some stuff, whether it's their first apartment, they got a car now, if they're in college and they get sick, they're a legal adult. So the school doesn't necessarily have to talk to you as a parent because they don't treat them as children anymore. So they're not looking at you as the parental figure anymore. So you want to definitely make sure you have those documents for sickness or illness in place so that if something happened to your child while they were away at college, they know who they have the authority to speak to. If you don't fill out a HIPAA, for example, and your kid is away at school, doctors may not be able to talk to those family members because they don't have that information and it's a violation of that person's privacy. So you want to make sure you have that in place. You want to have a healthcare directive in place starting at the age of 18. And like I said, as you continue to accumulate, that's when you start to think more about a will. But for my 14-year-olds, no, not ready yet. Oh, so these are some of the mistakes that I see all the time. People find stuff on the internet, and the internet is our education source nowadays. And so you just have to be careful with what you find on there. I see a lot of DIYs. People find there's services that you can pay $60 and get a will, or even to pay $100 and get a trust. And I tell people you get what you pay for. You will not know if they're wrong or right, because the unfortunate reality is these documents don't come into play until you've passed away. And so if you got it wrong, you will not know, but your family certainly will, because they're the ones left trying to sort it all out. We have a case right now, a young man decided to draft his grandmother's will. He's trying to get us to help him untangle the mess he's made. He found it on the internet, and essentially he wrote himself out of the will by accident. And he's trying to figure out, how do we write you back in now? I'm like, no, it's gone. She's gone. There's no way to fix this. Sorry. So that's a really hard thing to say to somebody. He's like, no, my grandma was very clear. She wanted half to me and half to my aunt. And now aunt, of course, has short memory. And she's like, I don't remember that conversation. The will says everything to me. Everything to me. So be very careful with the things that you find on the internet. A lot of times we see people say, well, I'll just put my kids on my bank accounts because that way if I get in an accident or if something happens to me, they'll have access to the funds. You have minor kids, they're not going to give them those funds. If you have older kids, now you've opened yourself up to a whole lot of liability. If that kid files for bankruptcy, now those funds that you may have in that joint account become subject to their bankruptcy. If that child decides they want to run off to Vegas with the money that's in that account, well, they're co-owner on the account, so they are more than entitled. So there's a lot of risk that happens when people decide, well, I'll just circumvent trying to do actual estate planning. I'll just put names on my accounts. I'll put some names on my deed. That'll be that. We see it all the time. There is just a lot of risk that people don't necessarily think of when they decide to do kind of a DIY estate plan. So, and I'll just tell you guys what happens in Georgia if you die without a will. There is just usually assets are divided between the spouse and the children if there are minor children. And then the children may be given equal amounts. But one of the things is if you die without a will and the courts are just going to give it blanket, they're going to say you left 3 kids, we're going to break it up. What if one of those kids is a special needs child? What if one of those kids is Usher Raymond? They don't need equally. Their needs are so different. And so if you don't put a plan in place that's going to take that kind of thing into consideration when you do no estate planning, just understand the courts are like, nope, a third, and a third, and that's going to be it. So that's where you want to really think about the types of tools that you're using when you know that you have different needs among your family members that you want to make you want to have planning for. So that's where a trust comes in. When you have a situation like you have a Usher Raymond and a special needs son, you need a tool that's really flexible, that's going to give you the ability to make allowances for the different places they're in life. And that's where a trust comes in. I am a huge fan of trust. So that's why we're talking about trust today, because you can do so much with a trust. You can put stipulations on when your children will get the funds that you want to leave them or the assets that you want to leave them. You can make trust for multiple generations, a dynasty trust, and you still get the power to really put provisions on when you think people should get the things that you want to leave them. So, excuse me, for example, sometimes we see parents say at the age of 25 or 35, when they feel like their kids are a little bit more mature and they can actually handle the funds, and even make them co-trustees so they can understand how their trust works, so that they understand what it takes to manage those different funds that you may leave them. You can use the trust to leave funds for charities. You could do the plethora of things. I mean, I've seen people say to my son, so long as he doesn't marry Keisha Nicole Jones, like you can put whatever stipulation you want on it. So the funds can go exactly where you want. And the court trusts have been treated pretty privately. If you go through the trouble of creating a trust, the courts are going to say, we're not really going to get involved. It will take a lot for the courts to invade a trust. So that gives you a protected layer of privacy. If you have a concern about family members fighting, or you need to leave different amounts to different people, but you don't necessarily want them to all know about what the other person gets, then a trust gives you that level of privacy. And that's usually a big thing for people who know that there is going to be drama when they pass away. So unlike a will is a public document. When you pass away, by law, they're supposed to file that will with the court. So any cousin can just come off the street and say, let me get a copy of that. Any cousin can then go and try to contest the will and say it was not your right will, or you were not in your right frame of mind when you drafted that will. So there's a lot of public space for people to interfere with your will. Trust, complete opposite, completely private. Only the people that need to know you have a trust will know exactly what's going on with the trust. So you typically share the trust information with the trustee or the person that's going to be left to administer that trust. And so the difference, a trust is a legal entity. And I try to explain a trust a couple of different ways. A trust is really a legal relationship in the sense that I leave money for the benefit of, say, Sam, but I put Rosalind in charge. So any money that I leave to Sam, Rosalind, based on the instructions that I've left her, knows when she can give the money to Sam. So if my instructions say, Rosalind, you can give Sam money on Tuesdays for a haircut, Rosalind, you can give money to Sam when he graduates from college. So it's really just a set of instructions that tell people when they can distribute those assets to someone else. So typically you have three parties to a trust: the grantor, which is the person that's leaving something, that's granting and giving of something. Then there's the trustee, that's the person that's managing the trust. And then there's the beneficiary. Those are the people who are going to receive from the trust. So a lot of trusts, irrevocable trust, typically the grantor and the trustee are the same person. I'm giving the trust, but I'm still very much alive. I'm going to manage the trust while I'm still alive. And then at the time of my passing, the successor trustee is the person that will step in and they will manage the trust at that time. And then there are two main types of trust: the revocable trust or irrevocable trust, and then the irrevocable trust. The irrevocable trust, the difference is once you put things in, it's pretty ironclad. That one, it's not coming back out. It takes a lot to be able to undo that trust. And so I get questions all the time. Well, why would anybody want to do that? If you got to give up so much control, put it in there and never get it back out. It really depends on where you are in life and the assets that you have. If you're already, lived a full life, not going to use these assets, they're really just for the sake of I want to pass them to the next generation, then you might be much in a different place where you can go ahead and give up your ownership interest in them and put them in the trust and kind of protect them for somebody else. Younger, minor kids, life is still changing, don't know where I'm going to be in a few years, then you want to consider a revocable trust, because you can put assets into the trust, you can take them right back out should your needs change, and you continue to manage that trust until you are either incapacitated, you're just physically not able to mentally take care of stuff anymore, or you've passed away and now your successor trustee has stepped in. Rosalind, we got a question?
And yes, it says, can you give an example of a dynasty trust?
A dynasty trust, have you ever heard of the Rockefellers? That's, the most probably famous one. It is really a generational trust. It is designed for the purpose of being able to leave funds for multiple generations. So typically I see 3 generations. People don't traditionally go farther than that in estate planning, but they can. That's the whole point is, okay, I want this many people to be able to benefit from it. So that's the biggest example, probably most notable one that's been going on forever.
Beyonce said her grandkids already rich.
Yes, and that's what she means by that. They will be all in the trust for them. And the thing is, like when people do, my law partner and I are talking about this, when people do it right, we never hear about it, because that's the whole point. They're not going to be in court. They're not going to be a whole bunch of drama. You just know that everybody's taken care of and the kids are taken care of. I don't know if you guys watched the Meghan Markle and her husband in an interview, but he did say there was funds from my mom because she did it right. There was a trust that was set up for the boys. And so he's living off of this money, and now, their children will be able to live off this money that Princess Diana left billions of years ago before she passed away. So that's all it is. It's just making sure multiple generations are able to benefit.
And then we have another question. It says, why do investors put their properties into a trust?
So a couple of things. Investors should put their property in different tools. If it's real estate, for example, making sure that they have a LLC, they get a different protection by being an LLC and then having an operating agreement. Those kind of help shield them from creditors and try to give them some protection there. Putting it in the trust means it's not in your name. And so if you get sued in your person, and that's what usually happens with investors or professionals, we tend to get sued sometimes. And so you want to take those things out of your name so that people aren't able to access those assets. So that's typically what you see when you see investors and people putting it in trust.
And then another question about land trust. So are those a good option for like your primary residence?
So primary residence can be put in a trust if it still has a mortgage on it. Only your primary residence. So if you're thinking about building a portfolio of multiple properties and they're all still mortgaged, you really want to think carefully about if you want to put them in a trust. Because when you put multiple properties that aren't your primary residence, very typically those mortgages have provisions in there that say if you make a transfer, they can call the mortgage. And so they're going to come looking for the whole amount. So you want to be careful with if you have multiple pieces of land or you have real estate, how many of them are going to go into a trust, if they're mortgaged, if they're not mortgaged.
That's good to know. Nobody want to pay the whole thing.
Right. That is a very sad feeling when you just be like, wait, what is this bill? What are you calling about exactly? So yeah, that can trigger it. So we always are very careful when people come to us with real estate and some investment properties on whether they should go into the trust. Let's see. Oh, I just explained that to you guys in terms of the different people in the trust. So trustees are the word says it, trust. You got to really know this person. Make sure it's somebody that's going to respect your wishes, that can understand the responsibility of managing a trust, because it can be a lot of work to administer a trust. You want to think about, is this person going to be able to invest the funds? Do they really understand investment and growth? Because if you're leaving money to, say, a 4-year-old, it's going to be sitting in that trust for a while. We don't want it to be sitting in just a traditional bank account. We want to make sure it's being invested and grown and, make some money. But you want to pick somebody that really understands that responsibility, because as a trustee, they have a responsibility to the 4-year-old, to the beneficiary. And so although they might be 4, when they get of age, they'll be like, well, what did you do with my money? Why didn't you invest it? Why didn't you do anything? So the trustee can be sued by the beneficiary if there's any mismanagement or if there's poor management of the trust. So you definitely want to think about the person you put in charge as a trustee. Sometimes people use corporate trustees. Corporate trustees are the bank or any financial institution that manages and administers trusts on somebody's behalf. There's nothing wrong with a corporate trustee. Their fees tend to be high, to be just very honest. They usually aren't interested in getting involved if the assets total less than about 800,000. Some won't, and that's a handful that will even take that. Most are $1 million and above. So if you're thinking, I don't have a family member that could actually serve as a trustee, you may want to think about outside of your family, or do you have some, colleagues or church members or sorority sisters or something else? Because sometimes I have people, they're like, no, I have no one. And that's when we'll say, okay, well, can we afford to look at a corporate trustee? Will the fees make sense? So we already talked about the beneficiary and then benefits of a trust. So in one sense, a trust is just like a will. It is going to pass your assets from one set of family members, one generation to the next generation. But the benefit is you avoid probate. I told you don't have to go to court in any way when it comes to using a trust. No court involvement, so you don't have them deciding who gets the assets or what's going to happen in the event that you were even incapacitated. Since you are the first trustee, you've made provisions in your trust to say what happens if I'm incapacitated, what happens if I have a stroke. The trust has language in there that already tells everybody what to do in that situation. And it really does bring all your assets together in kind of one place. We have bank accounts over here. We got real estate over here. We got some stock, certificates over here. Well, the trust can own all of that. And that one person as the trustee can manage all those assets at the same time, all in one place, and then have directions on how those assets will be distributed at a later date. And like I've talked about the privacy already. And again, with the revocable, you can change it.
Does a trust override a will?
Override may not be the right word. Typically, when I draft a trust, most attorneys that draft a trust, we draft a will in tandem with the trust, because most people, they will fund their trust, and then suppose, you go, you play the lotto, you hit it big, you buy up a whole bunch of stuff, but you never came back to your trust. You never put those investments and all these other assets in the trust. And so you then die, and these things are outside of the ownership of the trust. So we typically draft what's called a pour over will that says, if I died and I have any assets that were not in my trust, put it in my trust. My instructions to you are put them in my trust, and then and however my trust was designed, that's how I want them handled. So they work together. This is the catch-all for anything that you may have left out when you passed away. So you're going to get a will and a trust, but you may not get, when you do a trust, you'll get a trust and a will. But when you do a will, you can do a trust within your will. I don't advise it. It's just, it doesn't give you the same level of control over your assets that you would if you did a trust in and of itself.
And then another good question, where do you create a trust? And so we know the warnings before, the do-it-yourselfers, the go online, but where should they go to get some resources to create their trust?
So to create a trust, you're going to need a lawyer. Just straight up, don't try to do it at home. Don't try to do it anywhere else. You're going to need to get with a lawyer who knows about doing trusts. Trust can be very simple, and it can be very complicated. You want to do multi-generation, you want to do some charitable giving, you have high assets. Trusts are taxed very different than other people. So you leave all these assets in a trust and they earn income. Well, that income is taxed. The IRS wants their money at all times. And so you're looking at being taxed at a 40% tax bracket. And so that's huge. So you have to really kind of understand, is it more important for me to leave this in a trust so that my children can get it at ages where they're much more able to manage it, versus understanding there is the tax consequences also that is going to hit whatever is left in the trust. So you really want to talk to somebody that understands trust. So the attorney's job is to draft the trust. Then you usually have your financial planners, your CPA, your tax advisor telling you what assets need to maybe go in the trust, what assets may not necessarily make sense to go in the trust. And then what are the tax consequences of whatever you decide to put in the trust. As far as a trust account, it's a bank account. It's just named in the name of the trust. You should be able to set up a trust account at pretty much any one of your local banks. I will tell you from experience, the big banks are typically more difficult, to put it nicely. So when you talk about your Bank of Americas and your Regions, it's just something about them. They put people through so much, and I don't know why. But the smaller banks, my clients always say they don't have as much problems, or even the online banks like Capital One and Ally, they're pretty easy about setting up an actual trust account. And then I tell people, a lot of times people have a lot of life insurance, for example. Life insurance, you have small kids, they're like, okay, well, I want to make sure that money goes to them. Well, you don't want to name them as the beneficiary on your life insurance because they are minor kids, and the life insurance company is not going to cut a check to a 7-year-old. I don't care if it's 100,000, 300,000, they're not going to do it. So what's going to happen is somebody's going to have to petition in court to become a conservator and have the insurance company then write the check to the conservator account that the courts require them to open. And at the time the child turns 18, all whatever's in that account goes straight to the child because it's their money. Okay, a lot of people say, I don't like that because my child turned 18 with $100,000. It's going to be gone before they're 19. So instead, you could have that life insurance pour into a trust, and the trust will hold those funds for that minor child. And so say your trust might say at 25 or 35 is when I would feel more comfortable with them getting that money.
And I think this is a good one. It says who keeps the trust documents. And especially when you talk about, I don't trust anybody to necessarily see, who should or where should you store these documents to make sure that people know that they exist and that when something happens, you can go ahead and have all those plans carried out?
So typically you normally have your original documents, and then you might want to share a copy set with whoever you've named as your successor trustee and have them really understand, hey, I'm setting this up and I'm setting it up in a way that you're the one that's going to kind of jump into place if something happens to me. And here's where I keep my originals. So I tell our clients, keep it in a safe, in a small safe like you can buy from Walmart, those fireproof safes that you can keep in your house. Make sure that the successor trustee knows where it is and can have access to the document. I hear sometimes people are like, well, I'm just going to keep it in my safe deposit box. I have a love-hate relationship with safe deposit boxes because if it's in there and nobody knows it's in there and nobody has access, then it's like you never did it. And so that completely defeats the point. So if you are going to keep and hold your documents in a safe deposit box, that's fine. But you're going to want to make sure that the trustee or whoever else needs to know about the documents has access to that safe deposit box. And when I say access, I don't mean just give them a key and tell them here's where you go if something happened to me. The bank is not going to let them in. So you need to add them onto the actual paperwork with the bank if you want to store them there.
That's always a big thing. People always say it's in my safe deposit box, but there are so many steps to go through.
Yes.
And the person who is granted your executor to get into the safe deposit box may not be the people on your document.
No.
And if they get in the box, they might say there's no will in there.
Right. Or, so if they don't have access, think about just from a logistical standpoint. You said, okay, well, my will is in my safe deposit box. Okay. You decided that you wanted to be buried and you outlined that in your will, but nobody knows that the will is in the safe deposit box. And so they cremated you months ago. Then they had to go get a court order to even get into the safe deposit box because nobody was on there. And then when they got in there, they was like, oh, she wanted to be buried. It's just it's not practical is my only point with that is sometimes it takes a while to get access to safe deposit boxes.
This is a good one. Someone says, so they've already created a trust, but they want to modify it. Mm-hmm. Should they use the same person or is it okay for them to use someone different for that modification?
You can use the same person or you can use someone different. I would start with the person that created it because lawyers typically don't like to amend other people's work. I will be very honest. If you come with a trust that's already drafted and I'm looking at it and I'm like, that's not how I would have done that. And I don't want you to have to bear the expense of that. So now it's different if you want to do a whole different type of plan. You with the first attorney was like, I'm only leaving money to my 2 children divided equally. You come to me talking about, I want to build a cathedral in my honor and leave money to charity. And I want it to skip 6 generations. Then I will tell you, we might need to start over. This is not going to work. But if it's a true amendment and I just want to update some names, I want to maybe change a distribution pattern or 2, start back with the attorney that drafted it. It's going to probably be the cheapest route. If you don't do that, most attorneys are going to say, no, it's going to be a restatement. And a restatement typically costs the full amount.
And is that state specific? So are trusts going to be something where you need to find, you're in Georgia, so all the Georgia people can call you, but if someone's in North Carolina, do they need to find a North Carolina attorney?
Yes, it is state specific in that sense. Your original drafting and setting it up, it is state specific. But the good thing about the trust is even if you moved, the trust is going to operate under, Georgia law if you're here with us, and everything is in there and owned by the trust. And so you don't have to keep changing it every time you move. Now, it gets a little tricky when you move to like California and some of these common law property states, and they just want to divide stuff real different. So you will look into it and see which one is more favorable and will actually line up with what you want to see happen. But for the most part, you don't have to change it when you move to most states.
Now, what about, especially right now, we're looking at post-COVID, and there are so many digital nomads. There are people who are leaving the United States and so forth. What about for them? Should they establish a trust in their last state of residence? Or is there something different or a different type of trust that they need to take into account?
They should go ahead and establish it where they last live, but they acquire property overseas where they are, understand that they may not talk well. The laws of where you are versus where you established it here may not work well. And sometimes it becomes a real problem for the trustee, because if you establish this trust here in Georgia, you named your cousin, they all live stateside, then you move to Europe or wherever, and then you pass there owning a considerable amount, they may just not have access and information and the ability to manage a whole nother portfolio overseas. So you're definitely going to want to make sure whatever you accumulate in those countries, you have provisions in place for them in those countries.
That's a good point. That's definitely something for everyone to think of, especially as people are moving around and becoming a lot more mobile in this digital age.
Oh yeah, I'm trying to be mobile too. I'm right there with you. I think that's it in terms of the trust versus will. I just went over most of this stuff in terms of you can use the trust and also have a will. And let me see. Trusts do avoid probate court. So if you are a person that's just like, I don't want, the courts to be in charge. I want to truly be the person that dictates how things are passed to the next generation, then you really want to strongly consider a trust, because probate court, things don't always go how people envisioned when it comes to leaving of assets. And it can be lengthy and expensive. When you start talking about family members fighting it out in court, and you've seen, celebrity headlines, but it doesn't have to be a celebrity. We have seen people fight for years in probate court over stuff. I have a lot of clients from the US Virgin Islands, and their probate process is just insane. And so I had a client that was telling me her uncle's estate they just finished probate. He died in 1982. They just finished 2 years ago. His wife has since died. His two children have since died. So all that drag out in court, and eventually nobody got it because they all died.
Gotta outlive them.
Yeah. But yeah, and that's the thing. If you don't want the courts
Oh no, it looks like we might have hit a little snag with Nicola. We did get some good information in and a couple of good questions too. I did see this one question. It talked about if someone has a will, is it possible that someone can contest it, and will the trust protect the successor? I know Nicola did go through this portion a little bit in terms of the will is going to be separate from the trust itself. And so the good thing about that, she talked about, and this is not me on my professional portion, but she talked a little bit about having the trust set up and then setting up the will separately. And more so than anything else is the will is going to protect you if you forgot anything. So if you win the lottery, you buy another house, you accumulate some outside assets, whatever they may be, your will can actually then trigger to fund the trust. So if you forgot to put something in the trust at another point in time, you'll have that great instance that this kind of makes up for the fact that you might have missed a couple of items here and there. So I think that's a really good question and just something to definitely remember. Here we go. She's coming back. I know she said she was in the midst of some of the storms. So,
Internet went back out. I'm so sorry about that.
but it's good because we were actually one of the questions that came through. It talked about will having the will, if someone contested the will, would the trust kind of help out in that scenario? And I know you had touched on that a little bit in terms of having them both. But definitely, if someone was contesting the will with that successor on the trust side, would they still have their assets in that kind of meantime as things are being contested? Oh no, we might have lost her again. I know we had a couple more questions in here. So I guess if she is still frozen for a bit, I know we have a few tornadoes out her way. So definitely she's weathering the storm. So if you have additional questions, definitely let us know. You can drop them in the chat as well. We'll give her a couple seconds or whatever to reconnect. But one of the things that we'll do also, if we missed any questions, what I'll do is when this posts to the YouTube channel, I'll make sure that Nicola has the link so she can go through and do some of that Q&A as well. So she can make sure that she addresses any questions, in this technology age, there is always something. So I want to thank you all for hanging out with us. And let's see if there's any other questions. And then just some great ones overall as we're planning for that next generation, planning for 2 generations. So many of us, as we think about having that next step or that step up in life, how much different things could have been if someone knew some of these ins and outs in terms of how to put things together, how to protect assets, how to plan for that next generation. But just like I talk about so many times, it's really part of putting the team together. So not simply just getting an attorney to put together the trust documents, but as Nicola talked about, is simply making sure that we have a CPA as well. She's back.
Sorry. Weather is not letting me be great today at all.
Well, perfect timing, because I was talking a little bit about from a trust perspective of making sure it's not just a single person, it's kind of putting together that team. I know you talked about your attorney is going to draft the documents. You want a CPA, of course, to talk about the taxation of your trust. And you talked a little bit about the financial advisor. Who are some of those people on the team? And then what are those things that they're doing as well?
So just like you mentioned, those people, the financial advisor, because just because the assets are in a trust, that doesn't mean you don't want them to grow, you don't want them to multiply, and you don't want, to be able to leave even more to family members. So you're still going to work in tandem with your financial advisors on the best ways to invest whatever those assets are in order for them to continue to grow. And like you said, the CPA is just there, is going to help you through the taxes, because it's a lot when it comes to taxes. Who else should be on your team? Those are your biggest 2, besides your attorney, of course.
A good question. It says, what's your thoughts on Susie Orman's product to create all these documents, irrevocable trust, will, and so forth, living will, etc. What are your thoughts?
I'm just gonna go back to my first point. You get what you pay for. Susie does a lot of things well. I don't know that I've never read anywhere that she has a law degree. I know Dave Ramsey and some of these other people in that space, they have drafting packets or documents you can buy from them or whatever. I think a large part of why you want to seek out an attorney and get counsel is we can advise you based on your particular family dynamic, as opposed to some standard form documents that you might be paying for that do not accomplish the goal that you have. Your family situation might be one where we need to do some very unique drafting to make sure that we get to the outcome that you want. And you're not going to be able to get that with these standard package stuff that they sell. I've looked at LegalZooms and I've looked at David Ramsey's. I've never looked at Susan Orman's actual documents, and I've just been like, okay, So,
But
like I
especially when
said,
you
you
talk
get
about
what you pay for.
things that are going to be particular to a particular state. That's even more important if you get this
Yes.
general packet and you don't know the caveats of your individual state.
Yes. And sometimes they're just like these drop down or eeny, meeny, miny, moles, and you're kind of forced into selecting from whatever these documents have. And so you're like, well, I'm not really in one of A or B, but those are the only ones that they've given me. So you're kind of forced to pick one of those, as opposed to having real counsel on that might not be the best thing or not. A lot of times our clients, what I hear in our meetings are, I never thought of that. And I'm like, you really shouldn't have. That's my job. My job is to kind of see for you all the different things that could potentially happen, and then have you say, okay, well, now given that information, I want to do something different with my assets. So you don't get the benefit of that when you just get these forms.
I think you made a good point earlier. You talked about the grandson that wrote himself out of the will. And it could just be simple.
Listen, I can't make this stuff up. That's the thing.
Because you're like, wait, am I this or am I that? Or what does that mean? Or what's the definition? And, I've gotten things confused and I'm like, wait, oh, hold on, that's not me. Like, and so if you don't know that and you accidentally make one wrong move, just like the grandson, he's trying to undo a legal document that he did.
And he did. And that's why I was like, there's no argument to make. There's no argument to make to the court that, oh, my bad, he messed up. Like, I can't do that. So you decided to take on drafting legal documents, then we're going to treat you like you knew what you were doing. So.
And this is the question I know everybody probably wants to know. What's the average cost of trust preparation?
So trust work is an investment. I don't gloss over that part, but with our office, we start at 4,995 and can go up. I mean, we have people in the 8s and 10,000, depending on the complexity of the type of trust that they're trying to establish. But yeah, it is an investment. It is how much of the work do I want to do on the front end, making sure that everything's protected and my family is going to be good when if something should happen.
And that's a question too. So they're paying this up front. Is there some annual or some maintenance, or how often should they be reviewing? I know someone talked about modifying the trust document. Is this a set it and forget it? So 10 years later, you're still with that same trust?
Oh my God, no. Oh my God, no. I'm so glad you brought that up. Do not set it and forget it. People are known for setting and forgetting when it comes to their estate planning. They're like, whoo, I got that done. I don't ever need to look at it again. No, people, every 3 to 5 years, you really need to look at your documents and make sure they're still consistent with what it is that you want. I just redid a trust for a woman because everybody named in the trust, the benefit from it are now dead. They've all predeceased her and she had to come back to the table, or she sold off a lot of the assets. She really wanted to just kind of say, you know what, everything to my nephew now. All that other very complex stuff, life has changed. So you want to, and life does change. You name your spouse, you love him to death. 5 years from now, you can't stand his name. Like, it's just those kind of things. Or you have adopted another child, or a child has predeceased you. Things just happen so fast. And so every 3 to 5 years, you want to say, yes, are these people still the people I would want in charge? Is this still what I would want to see happen with my assets? As far as pricing, I look for a law firm that does some type of a maintenance plan. When you do decide to go and get your documents drafted, that helps with the cost of having to do updates and changes, because the law also keeps changing. So you never want to just set it and forget it, because what was the law when you had it drafted may not be the law anymore. Taxes being the most obvious part. The tax code changes with every presidential administration. Some of that being how things are taxed that are part of your estate, and that could affect your estate. So you definitely want to not just stick this in a drawer, because the law may have changed concerning your assets. So with a maintenance plan, typically those law firms have you pay either yearly, a small fee, And then by the time it's time for you to either revise your documents, amend your documents, or make any updates, the fee is not as great the next time to make those changes.
Now, a lot of people are talking about the trust for when you pass away. But what if, and we'll all pass away, but there are definitely going to be some times where you may live, but you're incapacitated. Is the trust a good vehicle to protect you in that situation? I've shared my story a lot about my sister who is still trying to recover from a stroke she had over a year ago. Is the trust going to be a way to protect your assets? So if something happens, you're in a coma for 2 years, somebody can't just come on and take everything that you have, those kind of things.
Yeah, it's actually perfect for that. There is typically when we draft a trust, there's a whole section about incapacitated, because again, you're typically the first trustee. So you're the person creating the trust and putting everything in it, but you're the first manager of the trust. And so the documents will say, in the event that I'm still alive and I can't manage the trust, what should happen then? Should we prioritize using these assets for my care? If I'm, quadriplegic and I need all kinds of medical needs, do we use the trust assets for that? Do we prioritize me, my spouse, or do we share equally between me, spouse, and children? We take all that into consideration. You can make those kind of elections about what happens if I'm incapacitated. And then it transitions to, and then here's what happens when I die. Who will take over and what their responsibility is. So it's perfect for incapacity, actually.
And I know we talked a little bit about this too, as we get older. So a lot of people are going to need some type of aid, some type of care. And so if you get to the point where now you have to go to a facility or what have you, and you have a few $100,000 saved, and the facility is going to say, great, give me $5,000 or $6,000 a month, versus someone else who they haven't saved a few $100,000, and then they'll say, great, the government will step in and they'll pay for you. Is this something there that you can utilize the trust in order to prevent or get around kind of going through all of your assets in your later years?
Absolutely. And that's something that I love talking about. So you about to I'm not gonna give them all the tea today. But especially when we're dealing with aging parents. So I don't know a lot of the people on here, but if you're dealing with aging parents and you're trying to figure out what's going to happen with their assets, and what if they have dementia and they need to go into a facility. The people, I usually say, the truly middle class in the middle, they've saved some, they've worked hard, they want to pass that to their children. They didn't foresee needing to go into a nursing home or some type of facility. They got dementia and having to pay a $6,000, $6,000 to $8,000 a month bill. And it's like, that's not really the spirit of why they had saved this. Or land that's been in your family for multiple generations. And now your mom needs to go into a nursing home and she's not going to qualify for government assistance because she still has this land in her name. So you can use a trust as a vehicle to move some of the things out of her name. It's very nuanced, and it's a lot of rules, and you have to really understand the Medicaid rules, both on the federal level and the state level, to then understand how to use trust as a tool to be able to preserve some of her assets. But it can be done, and it's something that you definitely want to consider if you have aging parents, to see what can we save out of their assets and still be able to get them the care they need in some type of facility.
And I think that's huge. That's another reason why those prepackaged plans aren't going to think that far out. You're talking about your great grandmother's land. You talked about your grandmother's land, and you're like, goodness gracious, are we going to have to give this up?
Yes.
Or do I have to take from my current nest egg,
right,
pay for this facility? Neither one is a great option. But then how do you plan to figure out which one is going to be the most cost effective, especially in that hard time? You're making decisions for an aging parent that's already stressful enough.
Exactly. And I think especially in our communities, because we tend to be land rich and cash poor. So you will see this land that has been this is now, fourth generation or fifth generation. And now having to make that decision, like, we got to sell it. We got to get rid of this for mom to be in this facility. And it's a very difficult place to be because the reason your ancestors acquired that land was to be able to give it to you guys and you ever, whether it be a homestead or whether it just be this property they did not foresee having to sell it off just to take care of mom. So it's a tough one.
But even more reason not to pick up just the prepackaged plan, because an attorney is going to walk you through and say, well, what do you plan to do? And they're going to look forward generations, but also look back generations too. Who else is living today? Who needs help today? And that's going to push a conversation that you probably wouldn't have had when you're kind of just going through checking boxes. And so I had to evolve from the prepackaged. Like, this is $49.99 and she
Right.
$4,009. Like, that's a different.
I get it. And I think you have to, at the end of the day, say what is truly important to me in terms of the fight, the drama, and the madness that could be left behind. Even with the $49.95 packet, it's gonna be drama and confusion. So it's almost like, well, should you have spent the money? Because it's not going to mitigate having drama and confusion. So
I think that's good stuff. We've had some really good questions.
yes, thank you guys. These have been really good questions. These have been really, really good.
And it doesn't matter if you're growing, and so you're growing your assets and you're trying to get to that point. Nicola, we definitely will share your contact information. So if people want to give you a call and say, am I at a point that it makes sense to have a trust? But just to be able to protect your assets in the today, and then for everything that you've worked for. My grandmother used to say it's small graves and large graves, which just means people die at different life stages. Some people pass before they even graduate high school. Some people are going to live to be 90, and then we're all going to kind of pass somewhere in between. But we don't know when that day is going to be. We don't know how our life is going to unfold in that in between, but we can take some control and at least protect as much as what you possibly can. Because if you become incapacitated for a few years, and then things get better, you don't want to get better, and you're like, and now I'm broke. I've been working. I'm broke.
Yeah. And that's real. That is so, so real. And I think if I wanted to just kind of leave you guys with anything, is start now. Like, don't wait. If you're just starting on this accumulation of wealth and, trying to establish something for another generation, don't think, oh, I don't have enough to start a trust yet, or I don't even have enough to do a will. You do. I promise you, you do. Because sometimes it's just doing the document so people have a clear understanding of how things need to go down. That's the value. You may not, you might say, well, I live in an apartment and I just got, some furniture and a couple of pieces of clothing, but you have 3 sisters. And so if you died and now all 3 are just fighting over that furniture and that piece of clothing, it can turn a huge rift into the family and change that family dynamics. And it would have been so much simpler for you to have just written something down and say, sofa to Keisha, furniture, clothes to Pam, and we would have been okay.
Start today.
Yes, start today.
Start today. Make the call. We definitely have given you some resources. So if you're in Georgia, if you are planning to leave, so if you are so far along on your fire journey and you're like, yep, I'm about to leave, to have those conversations before you leave so you can start to plot some of those things out, are just key. And I want to thank our host, or our co-host, our panelist, our presenter today. So much good information, and she didn't even get into the meat of everything. So if something you were like, I need to talk, call her.
Yes. And Rosalind knows I'm a nerd about this stuff. I love it. I love what I do. I think it's fascinating. I think it is fascinating. I think other our counterparts have been using this stuff for a long time. Making sure that their wealth is protected and it goes to other family members. And I think just as a group, we need to catch up. We need to be able to use the same tools and be able to make sure we keep our stuff in the family and out of the courtroom.
And there's only a few Black specialists in the estate planning world.
Yeah. It needs to be more of us. I'm working on that. I'm seriously working on that. I have a network here in Georgia. It's a handful of us and we get together regularly. But I do get a lot of my clients from all over the state because they're like, you look like us. And we looked everywhere. We can't find nobody close to me. So
And speak the language, because your
yes.
cousin ain't really your cousin by blood.
Listen, and that is so key. Like
He is your mama best friend, so that's really
yes.
not family.
There is a cultural difference that really does play a role. And so you want to even take that into consideration when you are looking for an attorney. Because I have people, I have older clients that be like, I want to leave this money to the church because they got a building fund. So when I die, I'm like, well, how long did I have this building fund? Like, give me more. Whereas somebody who doesn't know the Black community and the church and the building fund will just gloss right on over that. And so then I'll talk to sister such and such. I'm like, well, do you want to just leave it to the church now? We can have a whole ceremony and a pew in your name. Like so we can have a real conversation. Whereas an attorney that does not understand our culture and the building fund and what that means and how exciting that is, probably will just gloss over it and be like, okay, she said building fund. That's that. Or, you keep talking about your aunties and you keep talking about your cousins and they never stop to ask, are they actually related to you?
Of course.
So it makes a difference. There's those nuances. It definitely makes a difference. So
Well, thank you so much. So many great gems tonight, and so many. I hope you all were taking notes, and you're like, "Goodness gracious, let me get this. Let me get this." Make sure that you have a phone call and at least discuss your situation and figure out what's the best course of action. Do it before it's too late, because once something happens, it's too late. And so definitely Nicola's information will be available. Reach out, have a call, have a conversation. And I want to thank you all for joining us for another Great Money Monday. Join us next Monday for another Great Money Monday. And so until next time, have a great evening.
Thank you guys for having me. Take care.